Now you can start. Kalyan. Good evening, Ananda.
Am I visible?
Yes, yes.
Sir,
If possible, please unmute yourself. Open your camera so that
I
speaker.
request all the participants to switch on their camera so that everybody is visible enough. Let me see. Right. Thank you. Thank you. I appreciate. Thank you for understanding it. And the topic is today's. We have a huge number of topics which has to be covered today, and it will be a long session. Please bear with the time. And if any doubts, please, at the end of the session, you can continue with your questions. Till then, please make a note of your doubts. Everyone will get a chance to ask the questions. Is it okay? If it is okay, please give me a thumbs up so that I can understand. Yeah. Thanks. Sir. Yes. Madam, co-host that మమ్మల్ని
Namaste, sir.
Okay.
Shall we start?
Yes, sir. Yes, sir. Please.
Shall we start?
Yes, sir.
Yes. Welcome to the second lecture. Continuation of the specific relief act, more particularly the specific performance of contract. It is contained.
Bit louder, sir.
It is contained in section 10 to 24 of the specific relief act. Yesterday, in the earlier lecture, I was dealing with 4 or 5 aspects. That is introduction, when the act came into force, separate law of equity, then who can sue for specific performance. Only to have a recap of only in 5 minutes, yesterday's lecture. First and foremost is specific relief act is a species of the Indian Contract Act of 1882. Previously, it was contained in the Indian Contract Act, and now it has been separated. And for the first time, the Specific Relief Act was passed in 1908, and the present act which we are implementing today is the Specific Relief Act of 1963. Like in UK, we don't have a separate law of equity in India, but the equitable principles are found in the Specific Relief Act and the various enactments pertaining to contracts. Here, the first and foremost is if you really only thing is you'll have to know the history of the common law, where the doctrine of specific performance was not available, because the common law never implemented the positive aspect, that is enforcement of a contract, or negative aspect, restraining the breach of or violation of a contract. Both of them were unknown as far as common law was concerned. Those were the deficiencies in the common law. It was sought to be corrected by introducing the law of equity. You know, in England, even today, they say king or queen is the fountainhead of justice. King is the supremo. Though she does not have ample powers, but still they respect the queen of England. Slowly, what happened was the petitions were being filed before the queen for redress. Whenever the common law courts used to shut out a party because only for a breach or violation, only damages used to be awarded. See, there is a saying in jurisprudence, justice should not only be done, but also deemed to be done. Whenever there are inadequacies or shortcomings in law, law should not be helpless to cure those shortcomings and come to the rescue of a person who pleads saying that he has got grievances. So for the first time, the equity courts presided over by the Lord Chancellor, now they are called the Prime Minister of England, introduced the law of equity, whereby they said, wherever the common law is deficient, the equity will step in and try to cure those deficiencies. In other words, if you are ill, you try to take vitamin tablets. In the same way, equity courts have come like a vitamin to step up and also provide remedies which was not available hitherto. But in India, when the India Sale of Goods Act was passed or introduced, they introduced various principles. And one of the cardinal principles of the lengthiest chapter in the Specific Relief Act is the specific performance. This is contained in section 10 to 24 of the Specific Relief Act. Of course, the question is, we are only having a broad outline of the Specific Relief Act and more particularly the Specific Relief Act, the Specific Performance of Contract. First and foremost is, when you make an agreement for sale of movable or immovable property, you must have a methodology of enforcing it whenever the other side violates or commits a breach of the contract. That is called the positive aspect of law. That is specific enforcement in the letter as well as the spirit. The main aim and object of specific performance is that an agreement which is made should be obeyed in the letter as well as the spirit by both the parties, be it the vendor or be it the vendee. And that is the object with which specific performance was introduced. This was the deficiency in the common law which was sought to be cured by the Specific Relief Act. Then coming to the founding principles of equity, it is based on two principles. One is, one who comes to equity must come with clean hands. And second aspect is, one who seeks equity must do equity. One who comes to court must come with clean hands doesn't mean wash your hands and then come. No. You have to lay all the cards on the table, lay all the facts on the table. Whatever documents you are trying to rely will have to be clearly placed so that the other side may be able to answer the grievances which you have made. You cannot have anything like a 3 cards game, hold the surprise card and hold the other side by surprise. No. Because I just take you to the CPC also, Order 6 Rule 2, which says plead and then prove, not prove and then plead. See, after all, even the contractual principles are dependent upon the various laws which are in existence. Here, the methodology through which an agreement is enforced in a court of law, specifically in the letter as well as the spirit, is called specific performance. What does it mean? As it is laid down. Then before going to specific performance, you must know the definition of instrument. What is exactly an instrument? Instrument from various professionals have different connotations. As far as a doctor is concerned or a surgeon is concerned, his instruments are the forceps and the other instruments in which he uses in performing the operation. But as far as a legal practitioner is concerned, his instrument is the instrumentation of law. An instrument is anything contained in a written document which contains various stipulations and various covenants. It is called an instrument. Please don't mistake. Instrument means an instrument which you use in cutting, so on and so forth. Instrument, according to law, is anything, a contract, an agreement which is reduced to writing, which both the parties enter into in order to fulfill them, is called an instrument. Instrument is of different types. You've got the sale deed, the agreement of sale, then you've got what is called gift deed, so on and so forth. But here, as far as the instrument from the point of understanding in the specific performance is, instrument is anything that is contained in writing. Am I making myself clear to you, please? So the object of section 10 is to formulate a principle whereby an agreement which is made shall not be violated by either parties. It should be fulfilled in full and complete. and there shall not be any complaints saying that the other side is a violator or you are the person who is aggrieved. Each person will have a different. In this regard, I would like to cite a quotation of Bentham, who was a leading jurist. He says, the law ought to assure me everything which is mine without forcing me to accept equivalent, although I have no particular objection to it. Please remember, today what is happening is, you know the prices of land. Today, what is the price? Tomorrow, it may not be the price. Today, let us say I enter into an agreement with you to purchase a property for 50 lakhs. Next day, that is tomorrow, the property escalates to 75 lakhs. Naturally, the greed or avarice of a person is, more particularly a seller, is to sell the property to a person who offers 75 lakhs and not to you who has offered 50 lakhs. So to prevent such abuses being done or to prevent such violations being done, law has introduced specific performance. When both of us agree, both of us reduce it to writing and spell out our contract inter se, the law should not be helpless to enforce such a contract. The other side cannot say, sir, I'm getting 25 lakhs more. I will sell it to that party who gives me 25 lakhs more and not to you. Please remember how much you are wounded. You are expecting a property, but what happens is ultimately the other side tries to take excuses and tries to violate. That is the reason specific performance has been. So this is the brief introduction which I have given yesterday in my lecture 1. Today we go further to say, the question is, there is one doctrine in law called privity of contract. What do you mean by privity of contract? A contract binds only privies to the contract. A stranger to a contract cannot sue on the contract. That's the basic principle of law. That is the reason you as a legal practitioner, when you draft an agreement of sale should be a replica of the sale deed. Only thing is, of course, it's an obligation to be performed at a later date. So the question is, you make it very, very clear. When you draft out an agreement of sale, the preamble has to be clearly mentioned. Why? Because nowadays, even though you have money, most of the people go for housing loans. When you go for housing loans, normally the flow of title plays a very important part. And then when you try to trace the family history of a particular family, you try to see what the father is, what the grandfather was, or what the great-grandfather was, what was their economic background, what was their social background, what is the financial background, so on and so forth. In the same way, when an instrument is drafted, more particularly an agreement of sale, it has to contain all the particulars, just like a sale deed. Here, first and foremost in an agreement of sale is the preamble is very important. Preamble is the introduction to the document. You say how the vendor has become the owner of the property, through which transaction he has become the owner of the property, either by sale, either by gift, either by partition, or either by a court decree, or by an auction purchase, so on and so forth. He acquires title to the property, or by partition also he acquires a title to the property. So that has to be clearly mentioned in the agreement of sale or in the agreement initial foundation of the contract between the parties. Second thing is, most of the people sell the property through their GPA holders. GPA holders are what is called general power of attorney agents. They are agents as far as the principal is concerned. They execute documents for and on behalf of the principal, and they undertake to register the document. They undertake to execute the sale deed. They try to say this is how the title has come, so on and so forth. They have got the power to sell the property. So when you draft out an instrument, more particularly an agreement of sale, it has to be properly drafted and the entire preamble has to be mentioned. The terms and conditions agreed between the parties are clearly mentioned in the instrument. And one more precaution which you have to take when you draft an instrument is schedule of property has to be clearly mentioned. Just like you describe yourself as Miss so-and-so or Mrs. so-and-so, wife of so-and-so, age so-and-so, occupation so-and-so, resident of so-and-so. In the same way, a property also has got its own description. But more particularly, agricultural land. Agricultural land, please remember, before an instrument is drafted, be very, very careful in going through all the documents which are given to you. Why? Because sometimes, please remember, the vendor may not disclose so many particulars. So for that, you call for those documents, inspect those documents, and then try to, because the party who comes to you depends on your legal acumen. And as a legal practitioner, you will have to go through all of them and try to mention. Please remember, the mistake which most of us do is mentioning the schedule. Because, nowadays, I think we are staying in Andhra and Telangana. We have a survey, let us say survey number 91. Survey number 91 consists of 150 acres. Survey number 91 has become survey number 91 by A. Survey number A, 91 by A, then E. Then again you go to U, then again A. Like that. What happens is subdivision takes place. I tell you why subdivision takes place. When a family consists of 5 sons, let us say, the entire land is divided between them. I am given given lands in survey number 91 by R. My brother gets survey in lands in survey number 99 by 90 by R. That is big R. Then E, so on and so forth. So this you can verify or try to find out only from the revenue documents. And in the revenue documents also, when you scrutinize the revenue documents, only few clauses are important. For example, you've got clause number 2. Clause number 2 mentions the survey number. Then clause number 3 or 4 mentions the extent of land. And other column also mentions the extent of land which is available. Then column number 11 is very important. Column number 11 shows the name of the pattedar. Pattedaru Peru. Then one important thing is column number 13, Akramanadaru Peru, the person who is in possession of the property. Then Sist, Gist and all, we are not concerned about that. But last column is what is called column number 45, which mentions the word Podi. Podi means how the property has been mutated, how it has been divided, in which file it has been done, how much each person is holding, so on and so forth will be mentioned there. But I don't know about your Andhra area. Here in Telangana, they introduced what is called the Dharani scheme. Dharani scheme is nothing but a big hoax. Here, what happened was, earlier, our founding fathers, when they prepared the revenue documents, they prepared it with great foresight. So many columns were there. We had the Pahani Patrika. Pahani Patrika is what is called the record of rights. And Kasra Pahani. Kasra Pahani means record of holdings. I'll give you the significance of Kasra Pahani. Record of holdings mean, during especially, I'm talking about United Andhra Pradesh. In 1947, there was police action in Hyderabad, where the Nizam of Hyderabad refused to accede to the Indian Union, and the Iron Man of India, Sardar Vallabhbhai Patel, who was the Home Minister, ordered for police action and also for combing the forest where it was infested with all these extremists. Then while combing the forest, in Telugu there is a caption, Dunne Vade Bhumi. So they introduced what is called the Rakshana Kavuldar. Rakshana Kavuldar means protected tenant, or Maifuz Kavuldar as it is called in Urdu. When the land is being cultivated not by you, but by a tenant who has been recognized as a protected tenant, but because he has been in possession of that land on that particular day, then in that case, he is given a certificate called 38E certificate under the Tenancy Act. That is called protected tenant certificate. The significance of that is a protected tenant gets 60% of the share in the property and 40% goes to the pattedar or the owner of the property. Why I'm trying to tell you that is, when you try to purchase a property, you try to make a search in the RDO's office where the PT register is maintained. Find out whether any protected tenant is there. And if you find out from the protected tenant, then you say that the owner cannot sell more than 40% of the property. Only 60% has to be sold by the protected tenant in case he wants to sell it. And without the consent of the protected tenant, the owner cannot sell. That is the normal rule. I think this is the same law that is prevailing in Andhra also. Kasra is nothing but record of holding. What they did was they updated the revenue records, and whoever was found in possession in 1953-54, they were given PT certificate, or what is called Rakshana Kauldar certificate, or in Urdu they call them as Mahfuz Kauldar. And a separate register is maintained called PT register. So as an advocate, when you draft out an instrument, I'm only giving the practical outlook. You will have to go through all the documents and see that these documents are available to you for scrutiny. Then the next question arises, now we don't have a separate Kasra Pahani. We only have the Adangal, or what is called the Pahani. In our Dharani, the lapses in Dharani was the Akramanadaru Peru, the person, I think this is not the position in Andhra. Here in Telangana, the word possessor has been removed from the Dharani scheme, where only the name of the Pattedar is mentioned. And as far as the possessor is concerned, that was left blank because for various reasons. I don't want to go into the political implications of that. And of course, these are all things. So the question is, like a scrupulous person, you will, as an advocate, because the party comes to you, because believing your legal knowledge and so on and so forth, try to inspect those documents and then come to a conclusion and then draft an instrument. Because the instrument is going to be the foundation of the ultimate contract between the parties. And one more important thing you must remember is, I think most of you are aware of also, that 17(1)(b) has been introduced to the Registration Act by amendment, whereby they say any transaction relating to immovable property has to be in writing and has to be duly registered. Any transaction relating to immovable property or which reserves an annual rent has to be reduced to writing and it has to be properly registered. So the question is, an agreement of sale also has to be registered. There is absolutely no going back on that. Then second thing is, lease. I think most of you know, when you give it on lease, mostly people use the word 11, use the figure 11 months. Why? Because it doesn't require registration earlier. But now, even if it's for 1 month or even if it's for 2 months, it has to be reduced to writing and it has to be duly registered. Without reducing it to writing and without getting it registered, the document is of no value to it, cannot be used as a primary document. So this amendment has come into force on 1/7/2001. So 17(b) has been introduced in the Registration Act, whereby it says all transactions relating to immovable property has to be reduced to writing and has to be duly registered. Then the question arises, sir, as far as revenue lands are concerned, what are the documents which I have to ask before drafting a document? First, as far as revenue land is concerned, you don't have sale deeds, etc., etc. You have the Pahanis, you have the Kasra, and you have the Chow Fasla, whatever it is. Then look into that document and satisfy yourself that whether such land exists or the particulars mentioned in that document is absolutely correct and true. And one more, the basic precaution which you have to take is, when you write the schedule of a document, you have to be very, very careful. Because schedule plays a very important part in identification of the property. Sometimes I'll give you one more instance. Then we'll finish this. Yeah. I'm trying to summarize everything. Then we come to development agreement. I think nowadays people are handing over old houses to the developers or the builders to construct. And normally the sharing ratio is 60-40 or 50-50 or 80-20 or whatever it is. There the question is, if you are purchasing from an owner, be very, very careful in finding out what are the flats which have come to the share of the owner. What are the flats which have come to the share of the developer? Then try to find out whether they have been clearly mentioned or not. And please remember, try to assure yourself that even a development agreement has to be duly registered. So there's no question of going back on that. Earlier, development agreements was not compulsory registerable. But after the amending act of 2000, amending act of 2001, even a development agreement has to be duly registered. Then come to, nowadays we are getting a lot of hybrid documents. Agreement of sale come GPA. Here, AGPA as they call it. Please remember, in one of the leading cases of the Supreme Court that's famously popularly called the Suraj Lamps case. I think I'm still, if I'm correct, it is about 2004 or 2005, where the lordships held, saying that an AGPA does not confer a title. AGPA is something like an agreement of sale alone. It cannot be a sale deed, provided if for an AGPA to be enforced, the entire consideration has to be paid, and the entire stamp duty has to be paid. Then alone an AGPA can be enforced in court. So a relief of specific performance will not lie as far as AGPA is concerned. I encountered this difficulty in one of my cases, which I argued before a district court. This judge was very fond of the Suraj Lamps case. And for every case, she was saying Suraj Lamps case, Suraj Lamps case. Please remember, don't get disheartened because the judges ask you a query. Because after all, judges are also human beings. They also commit mistakes. You can carefully distinguish it by saying, sir, in my document, the entire consideration has been paid. Entire stamp duty has been paid. There is no hitch as far as the document is concerned. So specific performance lies. So Suraj Lamps case does not apply as far as my case is concerned. That's how you get over a judgment or a precedent which has already been established. Then as far as dwelling houses are concerned, shops are concerned, all those things are concerned, there's no problem because you've got written documents. So the question is, because the person who is here, I think Mr. Nageshwar Rao, who is a senior advocate, he knows that మనం పూర్తి చరిత్ర చదవాలండి. వాడికి ఎట్లా టైటిల్ వచ్చింది, వాడు ఎట్లా ఓనర్ అయినాడు, వాడికి పార్టీషన్లో వచ్చిందా, సేల్లో వచ్చిందా, గిఫ్ట్లో వచ్చిందా, కోర్ట్ డిగ్రీలో వచ్చిందా, పార్టీషన్లో వచ్చిందా, ఇదంతా మనం సంథింగ్ లైక్ వాట్ ఈస్ కాల్డ్ వెన్ వి ట్రై టు, అఫ్ కోర్స్ I don't go to races, but the question is, we try to bet on the horse which is going to win. We don't bet on the horse which is going to lose. And we make a study. మనం లా చదువుతామో లేదో కానీ when we try to go to races, so many people give our tips so that we get the jackpot. In the same way, please remember, a client comes to you with full confidence. Don't let down your client. And don't be in a hurry, because even in రాయకపోతే వేరే వకీల్ దగ్గర పోతాడో ఏమని పోతే పోనీ, don't bother about it. Try to be conscious. So with this introduction, we'll go. I'm making myself clear to you, please. Now, the next question that arises is, here, I think the quotation I'll try to amplify. Bentham's quotation, which has been cited in most of the judgments also. He says, Bentham says, the law ought to assure me everything which is sure, without forcing me to accept equivalent, although I have no particular objection to it. Please remember, I have got some of you are residing in Vijayawada. You know, there are some posh places like Governor-Peta, Satyanarayanpuram, Besant Road, so on and so forth. I want to purchase a property there. Then let us say we make a contract. I have got special liking for that. But he says, మీకు వద్దండి బీసెంట్ రోడ్ లో కాదు, మీకు అక్కడ కోర్టు దగ్గరనే రాజగోపాల్ రెడ్డి నగర్ ఆర్ సంథింగ్ వేర్ యువర్ సివిల్ కోర్ట్స్ ఆర్ లొకేటెడ్ ఇన్ విజయవాడ, మీకు అక్కడ ప్రాపర్టీ ఇస్తానండి, ఇది ఎందుకని? Please remember, I don't want that property. I want only the property at Besant Road. Only I'm interested to purchase that, even though it may be more valuable, but I got a sentimental attachment for Besant Road. So the question is, the vendor cannot say you accept any other thing, but not this. Please remember, when we have some sentimental attachment to a particular property, we want to purchase that property not only for yourself, but your family. The vendor cannot dictate terms to you. Though the alternative that is given to you may be more lucrative, but still it is not an answer. That is the reason Bentham says, I expected that I'll get this property. When I expected that, my expectation should be fulfilled. And that expectation will be fulfilled only when I get that property. The vendor cannot say, I'll give you some other property, accept that. No. Question is, I want only this property. And normally, if you see, agricultural lands are more side road undantaru. That is usually the vantage point. I've gone for a particular land which is on the main road, which is bounded by three sides road. He cannot say, I will give you somewhere in the corner, you take that and not this. Though I'm going to purchase the same land in the same survey number, but not that land which I agreed to, which I wanted to purchase. So the question is, law says what you expect should be returned. That is the reason why specific performance. Am I making myself clear to you, please? Then one more factor that has come into play now is escalation of prices. This is throughout, sir. Here in Andhra or Telangana, prices are rising every day. On the day when a contract is made, there's a particular price. On the day when the enforcement comes, naturally there is escalation. Escalation is not a ground for refusing to perform a contract. Suppose today I agree to purchase it for 50 lakhs. Tomorrow it comes to 75 lakhs. The vendor cannot say, I'm going to get 25 lakhs more. Here is your 50 lakhs and 5 lakhs more. Take this and get lost. No. That is not the aim and ambition or the object of specific performance. The object of specific performance is what I expect, what I anticipate from you, what property I have agreed to purchase, be it on sentimental value or for some other value, I should get it. That is the reason why Bentham says, I cannot accept anything less than that. I mean, am I making myself clear to you, please? Then one more aspect which has to be considered in specific performance is, normally what happens is, general power of attorney is a document. Previously, it was not registerable. GPA is where you appoint an agent to act on your behalf. First, try to assure yourself whether the GPA has been properly registered or not. That registration alone gives the right to the GPA holder to sell the property to you. Without registration of the GPA, the document cannot be acted upon, your sale deed will be refused. Then the question is, if your client still wants, try to go to the registrar office. This is what the banks expect us to do. You'll have to go and find out whether really the document has been registered, whether there has been double registration, triple registration, or 4 registrations. You will have to satisfy yourself. Make a search and then try to find out. Or try, and safest part of it is give a paper publication, a public notice saying that your client wants to purchase the property. Anyone having any right to do so or any objection should intimate undersigned within 7 days from the date of receipt of the notice, failing which the transaction will be completed. Why? Because that is why publication in a newspaper is constructive notice to entire public to ensure that there is no encumbrances on the property. One more advantage of giving a paper publication is the banks, especially when they advance loans by taking a collateral security, what they try to do is that is not registered. They only take by depositing the documents, and it is entered in their books, of course. And there is no corresponding entry in the register, in the books of the registrar. So books of the registrar, even if you take the Takatu Patram or what is called the encumbrance certificate, it will show the title of your vendor. But this particular document, where the document is, you do not know. So that is one. I encountered this problem when I gave a legal opinion regarding a very big man in pharmaceutical, I mean a big magnate in medical profession, that is CDR Hospital. The financial controller came to me and said, sir, my boss owns extensive properties in Gandipet. Of course, Gandipet is known for rave parties and all. And I said, where are the original documents? Sir, my boss has lost all the documents, sir. Only Xerox copies and certified copies are available. Then I asked him a simple question. Sir, did you give a paper publication? Did you lodge a FIR? And then try to get the originals? No, sir, we have not given it. Then I said, I wanted to wash off my hands by saying, I can help you, but I will not get. He said, sir, you know that who is the boss of CDR Hospital, Mr. C. Dayakar Reddy. I said, whether CDR or FDR or TDR, I'm not bothered. The documents are correct, I'll pass the documents. If not, you hang yourself. Then that we gave a paper publication, we took an indemnity bond and also lodged an FIR, so on and so forth. Ultimately, the loan was given. Because I am not the loan granting authority, it is only the head office which grants it. So I wanted to save myself by taking all precautions. So please remember, these are all the difficulties which we encounter in our day-to-day profession. So try to find out, even no party will give you the original documents. Parties will only give you the Xerox copies. If they give you the Xerox copies, try to get all the documents and then draft an instrument. An instrument, please remember, again I'm repeating it, your schedule has to be very, very clear. Sariyadulu antara chudandi Telugulo, that is Vistirnam Tarvata Sariyadulu, that is east, west, north, south. Just like you describe yourself as wife of so-and-so, age so-and-so, occupation so-and-so, resident of so-and-so, even a property has got a proper description. So description in the schedule plays a very important part. But if you want to show the seeds of litigation, mention a wrong schedule. That is professionally improper also. So try to help your client in this way. So now we go into the later part of it. Saying what I've covered today is by repetition is section 10. There are various judgments also. Please remember, just because you come to the court and file a suit for specific performance and want an agreement to be enforced, it doesn't mean that the court should grant it immediately. No, court will have to look into the various aspects and then come to a proper conclusion. Here, first and foremost is, I told you that specific performance is based on the equitable principle, saying that one who seeks equity must do equity. That is, the question is, suppose you agree to purchase a property for 50 lakhs, you pay 10 lakhs in advance and 40 lakhs to be paid at the time of registration. You must be ready and willing to perform your part of the contract by having enough cash balance of 40 lakhs. In case the court asks you to pay, you must be prepared to pay. But the case law on that aspect is, it doesn't mean that you must immediately deposit. You can say, this is my financial standing, financial solvency. I can arrange the money and I can tender the money whenever the court orders. So the first thing is, one who seeks equity must seek equity. That means one who seeks equity must do equity. That means you must be prepared, or you must be ready and willing to pay and deposit the balance of the sale consideration as and when called upon by the court. But you don't have a penny in your pocket, but you still say the other side has violated the terms of the contract, court will not come to your rescue. Am I making myself clear to you, please? Then we come to what is called the second aspect. In all cases, specific performance is not granted. Some of the cases, what happens is, the contract runs into various minute details. I'll put it this way. You know, there's a word in English called mitigation of damages. Here, suppose let us say 150 acres are there. I want to purchase 150 acres. 100 acres belongs to your vendor and 50 acres belongs to some other person, his sister or his wife or whomsoever it may be. But at the time of entering into an agreement, the vendor says, sir, I will sell you that 150 acres. Please pay me the substantial advance for that 150 acres. Later on, it is found that your vendor has got title only to the 100 acres and not to the 150 acres. That 50 acres belongs to some other person. And he has promised to get a clearance from her and then sell the property to you. Then the question is, the contract cannot be performed as a whole, but it can be performed only to the extent of 100 acres. I'll tell you the reason why. There is a maxim called nemo dat quod non habet. In the transfer of property, no man can pass a better title than what he himself has.
What does the specific when it comes to the registration process?
Yeah.
No, there is a doubt raised here. There is a doubt raised by Mr. Jacob. Student. New paper publication pushes aside the genuine owner. Somebody raised a question. Sir Jacob Garu, we will answer your question definitely. Please make a note of it. Not at this place at this time. We'll
Thank you, sir. Thank you.
definitely come to you. Let the session go on. Sir, go ahead.
Then the question arises, this is as far as the scope of section 10 is concerned. Then the question arises, who may file a suit for specific performance? I told you, privity of contract. The law of privity of contract says contract binds only previous to the contract. A stranger to a contract cannot sue on the contract. That is the reason when we draft a document, we say, hereinafter called the vendor or vendee, which term shall include all his heirs, legal representatives, and transferees in interest. What does it mean? It means not only a party to the contract, but your son or daughter, suppose, let us say by chance, by misfortune, if one of the parties expires, an action can be brought by the legal representatives, action can be brought by the assignees, or action can be brought by the transferees in interest also. So the law of privity of contract does not apply as far as an agreement of sale. That is the reason when we draft a document, we have to take the precaution of saying which term shall include all their heirs, assigns, and legal representatives.
So we can get into LIC. When the privity of contract is in. Take that as an example, that will be for the privity of contract. LIC. LIC is in privity of contract.
Then we come to another aspect. See, suppose what happens is, there are people who are purchasing litigation properties. These are very, very common, be it any area. He says, I will take over the litigation, don't bother about it. We are interested to purchase it. Then in that case, let us say you take a housing loan from whichever financial institution is concerned. And let us say you have taken a housing loan of 1 crore. Out of 1 crore, you have paid the EMIs only to the extent of 30 lakhs. Remaining 70 lakhs you have not paid. The vendor or the prospective purchaser says, sir, I will pay the money to the bank or the financial institution.
Is it audible to everyone? Is it audible to any?
Yes, sir. Yes, sir.
Yes,
sir.
sir. Yes, sir. It is audible.
Why the question
Yes,
is
sir.
not audible? That's what the reason is. BS sir. Some RC sir. RC. BS sir. BS sir, sir says his voice is breaking. Is it audible? All right. Sir, miscellaneous content, when replace and LLC vacancy of judge the question, and we have to time that. Because the agreement of sale, there are the points lagging. So that would be helpful for this.
Is audible. Anyone have any problem, then they will log out and again they will log in.
End of the session, please.
Please adjust the value.
Carry answer.
Yes. Sir. So the question is, suppose a person goes for a housing loan and then let us say 70 lakhs is due by your vendor to the financial institution. And a person purchases for a lesser price than what normally it is sold. Then in that case, the privity of contract arises. Can you pay the money on behalf of your vendor? The financial institution says, sir, money is your welcome, sir. Please pay the money, but we will not give the documents to you. Because the documents are to be handed over to the vendor and not to you as a purchaser. Then in that case, what you have to do cleverly, in the agreement of sale itself, you mention, sir, housing loan has been obtained, housing loan number so-and-so, for so-and-so amount, and out of that, EMIs have been paid up to the extent of 30 lakhs. 70 lakhs is due to the bank or a financial institution. The vendor has undertaken to pay that money to the financial institution and to facilitate the redemption of the documents, and to be on the safe side so that the financial institution hands over the documents to you, you try to take a GPA from your vendor and say authorizing you as the purchaser to redeem the documents and accept the documents on behalf of the vendor. Please remember this problem we encountered in a particular matter where we wanted to deposit the money with the financial institution and get the document. But what the financial institution said was, sir, there is no privity of contract between you and us. They submit a document which empowers you to pay the money and then hand over the documents to you, then alone we'll hand over. So these problems definitely arise. In the agreement of sale itself, you try to mention all these things because to be on the safe side, tomorrow you want to go for specific performance, you can always have the right of enforcing the contract by making the financier also a party to the litigation. Then we come to, that's what I was trying to tell you. Who may file a suit? A suit can be filed either by the party himself, or by his legal representative, or by his transferees in interest, or by his assignee on his behalf. So there's no hard and fast rule to say only the party to the contract can bring a suit. No, it is very, very wide. And what you have to satisfy in a suit for specific performances, first and foremost is sir, I am ready and willing to perform my part of my obligations. The other side is a violator. Please compel the other side to sell the property to me. Sir, can we have a break for 5 minutes, please? 5 minutes. Any doubts you have got, kindly note it down so that I can answer the doubts at the end of the session. Just 5 minutes, please.
Yes, sir.
But the heat here is unbearable, you know.
The persons who are new to this class, you please text your number so that the next time we will send you the link. We will add you in the WhatsApp group. Tomorrow onwards, we have class on Indian Evidence Act and a new Evidence Act for 30 days in the morning hours by Krishnaya Garu, who is retired judge, district judge. And I will send you the link also to you. You please try to join. You'll get to know many things. Over to you, sir.
Good. We'll continue the lecture. Here, so this is the broad outline of section 10 of the contract, specifically defined. Then we go into the other aspect. I said, who may sue for specific performance? I already gave you the example. Then we come to what are the instances where specific performance is refused. Say, to prove and satisfy the court, you must say, sir, any amount of money for violation will not satisfy me because I have got an intrinsic attachment to that agreement of sale. I want that agreement to be performed in toto. But sometimes when there is no standard of ascertaining the money compensation, court has no other alternative than to pass a decree for specific purpose. First and foremost is, what are the conditions you have to satisfy in order to get a decree for specific purpose? One is conduct of the plaintiff. That is, the conduct of the plaintiff should be above board. He should not be the violator. He has not committed a breach of the contract. He has come to the court at the right time, and it is not barred by limitation. And also must say, I am ready and willing to perform my part of the obligation. I am the person who is wrong. The other person has committed, he is the violator. So these are the basic ingredients which you have to satisfy the court before getting a decree for specific performance. In some matters, what happens is, contract cannot be performed for various reasons. Let us say I want to purchase a winery. Government, now liquor is given rise to a lot of complications also. I don't want to go into that liquor scam. The question is, liquor is the most profitable business if you ask me now, because you invest about 10,000 rupees, you get an income of 1 lakh. So of course, not that I am going to do a liquor business and all, but what happens is the government tries to introduce a policy of prohibition, whereby they say either the trade was legal, but subsequently it has been declared as unlawful because no one can carry on liquor business, which is prohibited. Then what happens is there is an impossibility also of performing the contract. Why? Because the question is the business has been made unlawful. So in that case, specific performance cannot be granted. Then second thing is, if you try to accept performance, let us say all of us try to go to the top surgeon or go to a top advocate. For example, most of you are practicing also. You know that by becoming gray, you achieve wisdom. RT says, this man is a white-haired person, he knows everything. So the question is, you try to go to a person because you want to accept performance from him and you know that he is capable of doing a case. But sometimes it so happens that after all, we are all mortals. Sometimes we get physically and mentally disabled also. We may not be able to do the case. Then we tell the client, sir, this is my practical position. I cannot do the case myself. Are you prepared to accept performance from my from my junior advocate who is also quite capable? But if the party says, sir, whether it is you or whether it is your junior who is properly instructed, I'm prepared to accept performance. Then in that case, a person cannot grumble by saying, sir, the senior agreed to do it, sir. He has not done it. He has committed a breach of contract. Ask him to do it. Please remember, when I'm incapable of doing it, the court cannot compel me to do that particular thing. This also applies to the case of a surgeon, to whom the topmost surgeon to whom you go. Sometimes what happens is he is afflicted with some ailment. Then his colleagues do the operation. But if you accept performance from his colleagues, you cannot grumble tomorrow saying that the other side has violated the terms of the contract. And please remember, sometimes the contract is so ambiguous and so vague, it does not contain all the material particulars. That's why I said schedule does not mention, suppose survey number 91. Where is survey number 91 by R, survey number 91 by R, survey number E, so on and so forth. When it is not properly given, when it is vague, when it is ambiguous, then in that particular case, the specific performance is refused. But in most of the cases, when you are able to prove an agreement, a subsisting agreement, an executory contract, where you have performed your part of your obligation, the rest of the obligations you're prepared to do it at a later date as per the terms of the contract, then in that case, specific performance will not be refused. But in other cases, just because you file a case doesn't mean that the court should decree the suit. You'll have to see what is the conduct of the party, how the party has come to court, whether he has come to the court within the time proper, and whether he has tendered the money correctly, whether he has done it in the reasonable way. All these factors will have to be gone into. And suppose, let us say, you don't have a penny in your pocket, but still you want the contract to be performed, law will not come to your rescue. But if the court refuses specific performance, then in that case, the court has to give reasons, and court has to say why specific performance cannot be granted. Without giving reasons, the court cannot pass a judgment or a decree. Of course, you know that you've got a right of going in appeal, so on and so forth. That is what is provided. Then, the one more thing which is very, very important is that here, suppose, let us say, the mostly bank loans, sir. I put it this way. You apply for a loan for, let us say, 1 crore. The bank does not grant you the loan immediately. You furnish some collateral security, the bank grants you a loan. Please remember, the word that is used is subject to maximum of so-and-so. Subject to maximum of so-and-so. That means at the time when you apply for loan, the bank grants you 20 lakhs, let us. The other 20 lakhs, so on and so forth, or you want additional limits. Then if you want additional limits, the bank insists upon you to furnish extra collateral security to cover the loan. You cannot complain saying, sir, bank disbursed the loan, bank accepted my loan proposal, they made all inspections, so I must get it and as per the old terms. No. That is the reason they say subject to a limit. That means even if additional limits are asked, additional collateral security is demanded from you. It cannot be made a ground for you to file a suit for specific performance and say additional collateral security cannot be claimed. And even if you file a suit for specific performance, court will not grant you a decree. Then we go to section 22. Section 22 of the Specific Relief Act, which says, here, the doctrine of unjust enrichment. Here, suppose, let us say, you want to avoid the contract. You don't want to perform the contract. You cannot have the money and then still avoid the contract. You have to pay back that money what you have taken. and then return it to the person concerned, those specific performance may not be granted. I'm talking about from the vendor's point of view. But here, sometimes when you go to the court beyond time, suppose let us say an agreement is there. It says within 45 days, you must pay the balance of the same consideration. You wait for considerable time, notices are given to you, you have been reminded from time and again to pay the balance, but you don't do it. Then in that case, specific performance will be refused because you have not performed your obligations within the time schedule. And that is the reason why an advocate, when he drafts an agreement of sale, drafts it very, very carefully to say, as and when called upon. As and when called upon అంటే ఎప్పుడైతే వాడు అడుగుతాడో అప్పుడు నేను సేల్ చేసి ఇస్తానని చెప్పి ఒప్పుకున్నాడు అని చెప్పి రాస్తాను. So that is means time is not the essence of the contract. Then you take the shelter under section 55(2) of the Transfer of Property Act to say time is not the essence of the contract as far as the agreement is concerned. So everything depends on your construction. Here, earlier what they used to do is, even though the specific performance decree is not granted, court will automatically order for return of the money what has been taken as advance. But now we have got our own judgment in our Telangana High Court to say, in equity, no doubt you are entitled, but you must also plead it as an alternative prayer. In the event of decree for specific performance not being granted, return of the advance and earnest money with interest at 24% or 18% per annum. Unless you plead it, your court will not grant it. Please remember, a child when it is hungry also tries to alert the mother by saying, by crying. That means, Amma na pali wala man. So the question is, you as a party should say, sir, in case specific performance is not possible, try to direct the other side to return the money with interest or whatever it is, specific performance may not be granted. Then we go into what is called, what are the instances, defenses that are available to a defendant in a suit for specific performance. In this regard, I take your attention to section 15 to 22 of the Contracts Act, which are concisely called the vitiating elements of contract. What are they? One is coercion, another is misrepresentation, another is fraud, another is undue influence, and another is mistake, unilateral and bilateral. Let us go one by one. Coercion. What do you mean by coercion? The agreement has been sought from, most of the films you know. Of course, don't be guided by cinematic sequences. వాడు ఏదో ఒక పత్రం తీసుకొస్తాడు, దాని దస్తావేజులు సంతకం పెడతాడు, విడాకు ఇచ్చినా కూడా దానికి సంతకం పెడితే విడాకు అయినట్టే. Please remember, courts are there to grant divorce. Courts are there to give you a decree. An agreement is there, you are asked to sign. Or a blank document where you are asked to sign, it is converted into a sale deed. Because please remember, thanks to Telgi scam, the question is now we don't require stamp paper also to draft a document. So straight away present the document, the reverse of it, they collect the stamp duty and registration charges and so on. Coercion means where you put a person to threat of injury, not only to himself, not only to him, but also to his family members, and try to obtain a document, an agreement of sale, let us say. Let us put it that way. When you try to take such a document, if the other side can definitely lodge a police complaint against you, sir, it has been taken from me under threat, it has been taken from me by coercion, please ask the other side to return the document as duly cancelled under the head of coercion. Coercion is when you put a person in threat of bodily fear or bodily injury and obtain a document, it is said coercion. Are you able to understand, please? Then we come to what is called misrepresentation. Misrepresentation is when a statement is made. Please remember, when you go to a GPA holder and say, Babu, ee bhoomi avadu anta manade anukondi. That means he says the entire thing belongs. Attosomu alududanam chestadu. What anta maade antadu. Don't be guided by that. He makes a statement. He has got a right only regarding a circumscribed limits and certain property. So here, where a person makes a statement recklessly without verifying its truth or otherwise to mislead the other person, it is called misrepresentation. Are you able to understand, please? Then we come to fraud. Fraud is a more dangerous weapon. That is what is called, I think you know the meaning of deceit, deception. Mosagad. Mosagad. Fraud means where you make a statement knowing fully well, having full knowledge that the statement made by you is absolutely false in order to deceive an opposite side with an intention of deceiving or cheating, that is called fraud. Then we come to undue influence. Undue influence means, suppose one person is in a dominating position compared to the other, that is in legal term is fiduciary position compared to the other, uses that position to his benefit and to the detriment of the other, and the other person to whom such influence has been employed has acted on your representation. Your representation changed his position, which you would not have done but for your representation. Then it is said it is vitiated by undue influence. Various examples can be given for that. That is Mother Superior and the disciple. Then your Guruji and Asaram Guruji and the Dera Sahib. So all these people who have got control over your mental faculties, they try to say you have to surrender everything to the mutt or to the ashram in order to join our. So the question is, sometimes what happens is we are completely hypnotized. So the question is, he has employed what is called undue influence on you. Then we come to a company and a shareholder. Company which issues a prospectus gives you a very rosy picture of the company, but there tries to induce you to invest in the share capital. Then based on that, you're completely surrendered to the company based on the representation you make it. You can say the company was in a position of undue influence or fiduciary capacity compared to me. A father and a son, guardian and a ward, husband and wife. Of course, I put it the reverse. Wife is in a fiduciary capacity because the talente allamu, bharya ante bellamatadu. So the question is, you are completely under the influence and you change your position, which you will not have done but for that. That is what is called undue influence. Then mistake, unilateral and bilateral. What do you mean by unilateral mistake? Unilateral mistake means where the mistake is only on one side. Suppose, let us say you want to purchase land in survey number 91, but you misunderstand it by saying the entire land in survey number 91 is going to be sold. The mistake is committed by you, not by the other person. Bilateral mistake is to say, suppose, let us say there is a building and the building has about 5 madgis or shops, let us say. The person who intended to sell the property intends that it's only 3 shops are sold, and both of us under that impression, when both of us commit a mistake as far as the identity is concerned, then it's called bilateral mistake. In all these instances, the contract is not void, but the contract is voidable. That is exercisable or avoidable at the instance of the party who has been misled. That is what section 15 to 22 of the Contract Act says. These are all the defenses that are available to you under the specific in a suit for specific performance. Then you've got what is called in the Contracts Act, you've got one section called section 56, doctrine of frustration. Let us, I told you also, at the time when we make the contract, it was perfectly lawful, but subsequently by the policy of the government, it has been declared as unlawful. Then in that case, you cannot perform your part of the contract. Then you are excused of specific performance. These are all the various instances of granting specific performance or not granting specific performance. But I would tell you that most of the cases which appear before the lower court, please remember what happens is the court should act judiciously. Unfortunately, what has happened is, I think my senior advocate also must be knowing that now the jurisdiction of courts have been increased. Now the titles, most of the title suits are coming before the junior civil judges. And till 20 lakhs, if I'm correct. From 20 lakhs to 50 lakhs, it is the sub-court. And above 50 lakhs, unlimited district court. Here the question is, junior courts, with due respect to them, are not equipped to deal with title suits. I mean, that is my impression. Why? Because thanks to the wrong judgment of the Supreme Court, which says the day when you pass out of the law college, you can become a judge. And now you've got the reservations and all, 33% reservation, this reservation. The question is automatically next day, once you get yourself enrolled, you can become a judge. Please remember, I could tell you honestly, sir, it takes you 10 years to know the alphabets of law. Practice is entirely different. Theory is entirely different. When I came to the profession, though my father was my senior, I never knew how to draft. I used to get scared to draft the title suit. Money suit, anyone can draft, but title suit, you have to be very, very careful in drafting it. So the question is, then issues under, what does it mean? Issues under Pilala, Pilakaila, left the Ammaila, left the Abbaila. Issues are not that. Points on which the parties are at variance, that is called issues. Then you've got pleadings, how you draft your pleadings. How, please remember, Andhra, I've seen most of the pleadings in Andhra area. What they say is complete denial will be there. Then the true facts, the defendant's defense, the true facts of the case, and the question is what your defense is. Because the CPC says you must not only deny it, but also try to spell out your defense. You cannot just succeed on the strength of the weakness on the, just you say that the other side's case is weak, my case has become stronger. No, you have to stand on your own legs. No one will give you the crutches to stand. So that is the reason pleading is an art. Then the question is, what I'm trying to tell you is that in a suit for specific performance, it is because Order 1 itself, CPC provides alternative and inconsistent pleadings. That is, in the alternative, you can ask for refund of the money with interest in case specific performance is not granted. Unless you plead that, the court will not grant you as a gratis. Though those days are gone, courts used to act mostly on equity. Now courts will not lean towards equity. So you have to necessarily plead. Then the question arises, sir, my client has to pay extra court fee. Not necessary. When you pay court fee on the higher relief, as far as specific performance is concerned, and then section 39, as far as our Court Fees Act is concerned, I do not know what is the section in Andhra. Here is 39. The entire money that is mentioned in the agreement, you pay the court fee. The alternative relief, you need not value it. Then another thing also is important. In a suit for specific performance, sometimes what happens is you suffer damage. You suffer mental agony and anguish also. No one stops you from claiming damages, but it should be reasonable. I think I take you to section 73 or 74 of the Contracts Act, which talks about liquidated damages and penalty. In my practice, I came across one document, agreement of sale, which is drafted by an advocate practicing prominently on the criminal side. It was handwritten and written on both sides of the stamp paper, where they say the vendor hereby agrees to sell and convey so-and-so. And in case the vendor does not sell the property or execute the sale deed, he shall pay double the amount what has been paid by the vendee. And in case the vendee does not pay, he shall pay double the consideration that has been mentioned in the document. Please remember, this is what is called penalty. When the amount you mention as the damages should not exceed the actual amount that is contracted for. If it exceeds that, it becomes a penalty. But reasonable amount as a probable amount, which you can claim in case of breach, then it is called liquidated damages. No one stops you from claiming liquidated damages, but shall not exceed the value of the document. That is what 73 and 74 of the Contracts Act says. So, of course, my lecture on Specific Relief Act has not been that exhaustive, but still the basic outlines of the Specific Relief Act, because most of you are all advocates already practicing, have fundamental knowledge as far as the law is concerned. These are the basic principles you have to keep in mind before drafting anything. Then we come to one more aspect which I've forgotten is agreement of sale and sale deed. Agreement of sale is where you use the word agree. The vendor hereby agrees to sell, convey so-and-so. Then in the sale deed, what do you write, sir? The vendor hereby sells, conveys, and grants all his right, title, and interest together with all easements and appurtenances unto the vendee for a total sales and consideration of so-and-so. After all, if you see the Contracts Act, if I'm correct, section 6 says offer, acceptance, consideration, consent. These are the only 4 elements that are necessary, and law and legality of object. But we as advocates, if we draft a document in a single page, client will not pay you the fees. And one page ki meeru 10,000 adugutunnarandi 20,000 adugutunnanu. So try to say, I am reminded of Abraham Lincoln, who says, describing the qualities of an advocate, he says, an advocate is fond of air splitting and pedantry. What does it mean? That means advocate evadaithe cross examination chestado idi mana original site la okkoka enchukaga piktadanu. That doesn't mean he acts as a barber. No, he tries to destroy the case of the adversary, fact by fact, document by document, and tries to win a case for him. Then pedantry. మీరు ముక్కు ఎక్కడ ఉందో ఆ బాబు అంటే ఇక్కడ ఉందని చూపిస్తారు యాజ్ అన్ ఆర్డినరీ పర్సన్. బట్ ఎన్ అడ్వకేట్ డస్ నాట్ షో దట్ హిస్ నోస్ ఇస్ హియర్. He come like this and say my nose is here. Not that your nose is going to become your eyes or it's going to become the ears, but that's how you succeed in. Because I still remember we came across various judges. అంటే మీరు విక్రమార్కుడు బేతాళుడు ఇది విన్నారా మీరు? దాంట్లో బేతాళుడు అడుగుతాను, నీ క్వశ్చన్స్ అడుగుతాను విక్రమార్కుడిని, నువ్వు ఆన్సర్ చేస్తే నేను వదిలేస్తా, లేకపోతే నువ్వు ఐ విల్ డిస్ట్రాయ్ యు. అప్పుడు క్వశ్చన్ ఇస్ జడ్జెస్ ఆర్ ఆల్సో మేడ్ ఆఫ్ దట్ టైప్. దే విల్ ఫ్రేమ్ క్వశ్చన్స్ 4 or 5 questions. మీరు ఆ 4 questions or 5 questions మీరు ఆన్సర్ చేశారని మీరు కేసు నెగ్గుతారు. బట్ ఆన్సర్ చేయలేదనుకోండి మీ కేసు గోవిందా అయిపోతుంది. సో దట్ ఈస్ ద రీజన్ జడ్జ్ ఆస్క్స్ ఎ క్వశ్చన్. You as a clever advocate, don't go to that answer. Go round and round and round. By the time the judge forgets the question which he has asked and the answer which you give, he accepts it. So that comes by promptness or intuition. You'll have to practice that. So, of course, this is as far as your specific performances. Then we come to some suspension of the period for bringing a suit. Sometimes what happens is, a comprehensive suit is filed for declaration or something else. Then there is an agreement of sale. Agreement of sale is there. Then an injunction is granted by the court not to sell this property, put it this way, not enforce that agreement. The period for which the injunction is there, or the period for which the stay order is there, period for which the prohibition is introduced by the government, that period is excluded for the purpose of computing the period of limitation. I think yesterday someone asked me about COVID. 2 years the COVID relaxation, COVID was there. Then that period, which COVID period, I think 2020 to 22 or 23, whatever, 22, I think. So that period is excluded for the purpose of computing the period of limitation. So if you see most of the enactments today, law has been made more flexible. Law has been, of course, I can put it in a lighter vein also. In one of the district courts, I was arguing a matter. I said, sir, well, what is the difference between a district judge and a senior judge? I said, senior judge is like a daughter-in-law and district judge is like a mother-in-law. Because no mother-in-law says my daughter-in-law is pure or she is correct. She tries to find fault with every act of the daughter-in-law. Fact-finding mission, fault-finding mission. Then I said, sir, as a mother-in-law, you must correct your daughter-in-law who has committed these mistakes as far as these aspects are concerned. Then I said, sir, I think you must be a mother-in-law by this time and must be having grandchildren. Yes, sir, I got grandchildren. But madam, by your looks, you look more like a newly married lady than a grandmother. She was so happy. Sir, sir, neelu kavalna, sir, cool drink kavalna. So I'm not saying because my friend lady is laughing. The question is, women are prone to flattery. Even the worst lady who is very, very cantankerous, you can bring them down by flattering, praising them to the sky. Nuve Mahalakshmi, Nuve Parvati, Nuve Saraswati. At that one, Nijagana Parvati, Nijagana Mahalakshmi, Editelu. Kani, you take them to cloud 9. So this is the doctrine of specific performance. Then the other scheme which I've introduced was a summary remedy that is provided to you in the specific fact in the form of section 6 and 7. Most of us are unaware of that. You know, you can only get a person dispossessed by due process of law. I think most of you know. You cannot use the mafia and try to get rid of a person. Try to throw out his articles and then try to take possession of the property. The person who has been dispossessed from property, other than by due process of law, he has got a right of filing a suit for putting him back into possession within 6 months from the date of decree. So please underline the word 6 months. 6 months from the date of decree, he can file a suit for specific for being put back into possession, provided he says that he has been in possession on the date of disposition. He has got documents to prove and establish his possession. And 3, he has been thrown out unceremoniously without resorting to legal procedure. Then in that case, he can file a suit for what is called being put back into possession. That is what section 6 and 7 of the specific relief access. But please underline the word 6 months. Within 6 months from the date of decree. Then the question arises, sir. Now, recently, what has happened is, I do not know about your Andhra area, but here, revenue authorities have been divested of their powers. You've got the special tribunals which are constituted under the revenues, that is special, the district collector, along with the joint collector and all, can hear matters arising under the Tenancies Act. Here, mostly sometimes what happens is there is a remedy, cheaper remedy provided to you under the Record of Rights Act, where you can get your wrong entries, where your name has been deleted from the revenue records. You can ask your name to be restored back and to remove the wrong entries. There is a summary remedy that is provided to you. You can straight away go to the MRO or the Tahsildar and get it rectified. But now, I'm talking about my Telangana area, where you cannot file, you cannot go before the revenue authorities. You have to file a suit for what is called rectification. Section 26 of the contract of the Specific Relief Act provides for rectification of entries. Of course, the court fee which you pay in such a suit is only 15 rupees, not more than that. And if there are 4 or 5 survey numbers where the errors have to be rectified, 15 rupees each. But of course, the Act, Section 43 of the Court Fees Act does not say whether you have to pay for every survey number or one survey number only. But please remember, you can take advantage of that and file a suit for rectification and get the entries rectified. But previously, you used to have what is called sale deed. Sometimes mostly discrepancies arise, sir. They would call it as printer's devil. See, nowadays, especially after the computer information technology has come, we are resorting to cut and paste. Sri ki Srimati aipothundi, Kumari ki Mrs. aipothundi, Mrs. ki Mr. aipothundi, so on and so forth. The schedule of property is also not correctly mentioned. Earlier, you can go to the registrar office and get it corrected, but the registrar now doesn't correct it unless both the parties appear. So the proper remedy for you is to file a suit for rectification under Section 26 of the specific law. Am I making myself clear? To rectify, rectification means it comes from the word rectify. Rectify means correct. Remove the wrong entry and mention the correct entry. Yes? I think we go to the question session, please. The rest of it, I'll deal with it tomorrow because I don't want to have an overdose. No, but tomorrow, let us clarify. We have only morning session in the world of evidence. The question interaction session, please. Or else, if you want me to proceed further, I'll proceed.
We plan it's the last session. Complete your task.
Then we go to rescission of contract. Rescission of contract. That is 27 and 28. What do you mean by rescission? R-E-S-C-I-S-S-I-O-N. Rescission means it comes from the word resign. Resign means retract. Retract means avoid. So that is called rescission of contract. This is based on the maxim, that is doctrine of unjust enrichment. Suppose, let us say you want to avoid the contract. You don't want to perform the contract in whole or in part. Then in that case, because of various reasons, I told you, vitiating elements of contract, then whatever benefits are had and received under such voidable contract, which you want to avoid, then the benefits which you have had, the money which you have received will have to be returned back to the opposite side before you get a decree for avoiding the contract. That is, in other words, they say in English, they say, you cannot have the cake and eat it too. If you want to have the cake, you suffer for that also. Before you'll have to take a knife, make it into pieces and eat. You cannot just gulp it completely. No one can gulp a loaf of cake just like that. It has to be made into pieces. The same way, if you want to avoid a contract by various reasons, fraud, misrepresentation, undue influence, mistake, unilateral and bilateral fraud, I mean, so on and so forth. Then in that case, you say that your consent is not free. It has been done in not in a proper way. then in that case, you have to, whatever benefits you have had and received, whatever money you have received from the other side, you have to restore back that money to the opposite side. Unless you do that, you cannot resign the contract or you cannot avoid the contract. That's what section 27 and 28 deals with. Then we go to the most important provision called cancellation of decrees and instruments. Cancellation of instruments and decrees. Suppose a document is vitiated by fraud, coercion, misrepresentation, undue influence, or mistake, unilateral and bilateral, and or let us say an instrument has been obtained from you under threat, then in that case, you want that if the document remains, it's going to cause enormous loss to you, then you can come to the court and file a suit for what is called cancellation of that instrument or cancellation of that decree by stating the various reasons. Then in that case, suppose the court is satisfied that the grievance made by you is genuine and correct, then the document which is obtained by you is cancelled by the court by a decree that is given. That is called cancellation of instruments and decrees. Sometimes what happens is a person who is a proper and necessary party to the suit, he has not been impleaded, but a decree has been obtained by fraud, by concealing, suppressing the material facts. Then in that case, the decree can be cancelled by the court, the same court which passed the decree within 3 years from the date when the decree has been passed. This is called cancellation. So cancellation also is an equitable relief. Just because you go to the court and ask for cancellation, the court will not grant you cancellation. You'll have to satisfy the various requirements, facts and documents, point by point, bit by bit. Then the document or whatever it is cancelled. Be it an instrument or be it a what is called a decree. But please remember one basic thing is that under Article 58 and 59 of the Limitation Act, a suit for cancellation of an instrument or a decree has to be brought within 3 years from the date of decree, not beyond that. So 3 years period has been mentioned as the limitation period for bringing a suit. But only a party to the decree who has been affected, or a person who's a decree which has been passed against him, he has not been made a party, he can challenge it. A stranger cannot challenge it as far as cancellation is concerned. Then we go into another aspect called what is called declaration. Declaration is contained in section 34 and 35 of the specific relief act, where they say where a position, a cadre, a character or relationship is pleaded by one party and denied by the opposite side, you can ask the position to be declared by a suit, filing a suit for declaration under 34 and 35. Most of you know that the recent experience has been that when a person dies, his legal heirs want to come on, want their property to be mutated. Declaration of legal heirs, as they call it. Declaration of legal heirs is the legal status. The word legal heirs is not mentioned. It is a legal status, whether they are the widow, sons or daughters of the dead person is concerned. That is, a court declares your legal status that you are the wife, you are the daughter, you are the son, so on and so forth. But if it is relating to immovable property, then please remember, half the market value of the property has to be paid to maintain a suit for declaration regarding an immovable property. Unfortunately, this is a judgment rendered by one of my students who became High Court judge and retired also, and is also one of the members of the Inquiry Commission, where it says half the market value has to be paid as far as maintaining a suit for declaration regarding property. I just, in one of the seminars, I met him and asked, sir, how did you write such a wrong judgment? I said, sir, a wife should not lose her husband. She has lost her husband, and you are a partaker in the booty. And the money, the property, which is the hard-earned property, ask the widow to pay half the market value. Is it not? Supreme Court challenge. This is the present state of affairs. I feel very bad for that particular judgment to say half the market. You are not the owner of the property, but still you ask the person to pay for half the market value. But unfortunately, that is the scenario today. Then I think I remember one of the cases in Constitution where what happened was the state of Bihar introduced an enactment by saying, I think they call it as a recovery of rents by distress, where here we call it as revenue recovery. There, what they said is, if a tenant is in default of rent, he has not paid the rent, and the landlord has been deprived of the rent, the landlord can bring a suit for recovery of the arrears. There, they said the state will take up the responsibility, but once the rents are recovered, state will take half, and half will be paid to the landlord. The Supreme Court put its leg on that and said it's a colorable legislation. After all, he is the landlord, state is not the landlord. And the దేవుడు వరం ఇచ్చినా కూడా పూజారి అడ్డు వచ్చాడు నువ్వెవడరా బాబు అని అడుగు కాన్స్టిట్యూషన్ Supreme Court. So these are all legislations which try to take away the rights of a party. Please remember, here the question is, state is no way interested. State has no right over that. But దాంట్లో వచ్చేదంటే నాకు సగం నాకు ఇవ్వంటే, is it not unjust? So here also I try to draw an analogy to the judgment of our High Court. Of course, I don't want to give the name of the person because he is now the chairman of a particular inquiry commission going into the what is called electricity dues. I think most of you know the name by this time, L. Narasimha Reddy. So the question is, I said, you have written a wrong judgment. I can call him by name and say, Narasimha Reddy garu meer rasindi tappu. ఏం చేయాలా బాబు వాడు సుప్రీం కోర్టు పోతాడని కూడా పోలేదని. Then one more instance also, I tell you, so many instances. Judicial, please remember, you say now the Consumer Protection Act, if I think most of you are aware, an advocate also is responsible for the deficiency of services, isn't it? You can be made liable in a consumer court, but that has been negated by the Supreme Court to say an advocate. In the same way, a judge also should be made accountable for giving wrong judgments, not following the precedents. Supreme Court judgment cite చేస్తారు నేను Supreme Court ఏమని రాస్తాను నా కోర్టు నేను వేరేగా రాస్తాను. Please remember, that is nothing but when a judge goes beyond the law, he commits a mistake, he should also be made accountable for writing wrong judgments. Perhaps the day is not far off when that law also will come, where judges are made accountable for the lapses committed by them. Of course, we do not know whether we live till that time. Then we go to declaration. Declaration is when a status, position, character is claimed by one person and it is denied by the other side, you can get a declaration from the court saying that you are entitled for that character. So I think most of you know in Telugu, Saviti Gola antaru, gurtunda meeku. Family courts, most of the disputes which arise today is after the death of the husband. Husband ki iddaru bharyelu untaru annamata. Both of them fighting for the terminal benefits. The first wife says, I am the legally wedded wife. Second wife says, I am the legally wedded wife. Because if they enter into a compromise, that's a different matter. Then who is the legally wedded wife? Then the second wife comes with a suit and says, I am the legally wedded wife. Modati bari eppudo vellipoyindi, desertion ayipoyindi, customary divorces. So the question is, because please remember, it is easy. No one, even in law, we say, no one says I am the lawfully wedded husband of a person. అందరిని lawfully wedded wife అని అంటారు కానీ lawfully wedded husband అన్నారు. The question is, a wife whose status is affected. A wife, please remember, in the society, if a wife is not claimed as a wife, you know what is the position. ఇరుగు పొరుగు వాళ్ళు ఏమంటారు మీకు తెలుసు. The question is, she wants her status to be declared. And even if you want to claim the terminal benefits, the employer says, please get a decree that you are the legally wedded wife. No one says, I'm the legally wedded husband. You only a legally wedded wife goes. Or suppose, let us say, mostly now elections, these things are arising. The question is, even in much these things are arising. A junior most pontiff is chosen as the successor. A senior is neglected. Then they go to court to declare as to who is the person who is entitled for that particular post. So the question is, declaration is when a status, position, character is claimed by one person and denied by the other person, then a declaration suit can be brought to declare a person entitled for a particular. And most of you who are practicing on the trial court also knows, you take an order for injunction, let us say interim injunction is taken or temporary injunction is taken. In spite of that injunction, construction goes on. Not to do the construction, the other side does it. But how to, after all, if you don't amend your plaint, you will have to amend your plaint and say, seek for the additional relief of declaration to demolish the structures by way of a proper relief. So you can also ask for all this. This is what, and declaration is the only remedy which is not executable, please. You cannot file an execution petition for a decree as far as declaration is concerned. Order 21 does not apply for 34 and 35.
Any questions, please?
I'll remind you that we are left only with two remedies. That is injunction and last one is what are the matters where relief is not granted. That is section 40. We'll continue it tomorrow. Any questions we can ask in interaction. Yes, sir.
Sir, please unmute yourself.
I'm not able to hear you, sir.
Nageswara Garu, please unmute yourself.
Please ask your questions. Yes.
Thank you. Now the host has allowed me to unmute, sir.
Yes, tell me, sir.
Sir, if I overlooked or otherwise, just kindly explain the other part of the rescission of the contract with reference to section 28 also, sir. Where in a suit for specific performance, the plaintiff default for the deposit of the money. Power of court to rescind the contract.
See, as far as section 28 or 27, 28 and 27 is concerned, rescission of contract is where consent is not free. Normally, it goes on voidability of the contract, where the vitiating elements of contract are present, like fraud, so on and so forth. Then the person who is aggrieved can ask the court, please permit me to resign from the contract. Then in that case, the question is whatever, suppose as a vendor, you receive the money, advance or whatever it is, then that money has to be restored back to the opposite side in case you want to get a decree for rescission. That is, you cannot get rescission as well as retain the money. That's why it is said unjust enrichment. You cannot enrich yourself, avoid the contract, but still retain the benefit. That the law does not permit you to do it. Yes.
Sir, in the Jaikar Garu,
Here the next mute question, sir. Power to extend time for deposit of time either on section 28 or 148 CPC generally can be exercised by the original court alone or can by the appellate court also.
No, original court itself, sir. Trial court itself. Then one more thing which I forgot in my lecture was I mistake unilateral and bilateral. That is 21 and 22. There are two things, identity of the party and identity of the subject matter. Identity of the party is where you say that you are contracting with Mr. Nageshwar Rao. It is not Nageshwar Rao, but some other person. But my impression is I am only entering into a contract with Nageshwar Rao. I mistake Nageshwar Rao to be some other Nageshwar Rao who has got a different initial or different family name. The question, there's a mistake regarding the identity of the person concerned with whom the contract is made. Identity of the subject matter is, I told you also, I want to purchase the property at Besant Road, but the person, he has the impression saying that the property at Rajagopal Reddy Nagar will be sold. Here there is no agreement or what is called consensus ad idem. Parties don't think in the same way, in the same sense. Then in that case, it's a case of mistake, unilateral or bilateral, whichever it may be, and the contract can be avoided. Again, coming to rescission, if I want to avoid the contract, whatever benefits I've had and received, I have to restore it back to the other side. I am making myself clear to you.
Sir, one more aspect.
Yes, sir.
You have already covered with reference to the GPSLs and all Suraj Lamp case.
Right.
But you kindly explain the power of attorney coupled with the interest in the subject
yes,
matter.
I think.
Because
yes,
that is the main center point and focus point.
Yes, sir. The power of attorney coupled with interest in immovable property is covered by section 202 of the Contracts Act, 202 to 217. That is what is called agency by necessity. There they say, even if the principal dies, the power of attorney does not come to an end. If the beneficiary, if the other party acquires an interest in immovable property, that interest will definitely get it irrespective of the death of the principal. That's what is laid down in section 202 of the Contracts Act. That is called agency by necessity. Provided, as you put it, that you must acquire an interest in immovable property. Mostly in development agreement, you see that the builder gets 60% and you get 40%. Right? And the builder
Because the document.
Yes, sir. Yes, sir.
In Suraj Lamp case also, except giving guidelines, they did not virtually give any finding on that particular aspect. But they have discussed about the scope of GPA and the effect of Section 53A of TP Act and
Yes,
other
sir.
things.
Exactly. Sir, am I making myself clear to you, sir?
So there is a.
What is the scope of the suit of within the meaning of Section 20, Section 10 of the Act, sir, after the amendment? Because
After-
earlier it is purely a discretionary. And
Now it is a matter
after
of, now,
2018,
I think the
subject
amendment
to Section.
took place by the amending act of 2018, where they say it's a matter of right. Readiness and willingness also need not be proved. Once an agreement
but,
is there,
but the discussion in the judicial mind is still continued.
exactly,
Because subject to Section 11, 14 and 16 of the
exactly,
Swachh effect.
exactly, sir.
Nashri, if you kindly excuse
Then
me.
finally, one thing for our friends to clarify, sir. Against whom the specific performance can be enforced. Because subsequent alienee with the notice of prior
performance can be
transaction.
filed against the vendor.
Section 19, scope of Section 19.
Exactly. It can be filed against the vendor or his legal representatives also, provided if the vendor dies, notice has to be given to the legal representatives to honor the contract. Then one more thing is that's Section 19, which speaks about bona fide purchase of a value without notice. There, as far as Section 19 is concerned, the person who says, even if a defective title is there, he purchases the property, he makes all inquiries possible, takes all precautions as a normal human being does, and the other person keeps quiet without correcting that person. However imperfect the title may be, his title and position cannot be disputed. Yes, sir.
And finally, sir, I don't want to trouble anything. Please explain to our friends the difference between earnest money and advance. Because you have well explained about the unfair enrichment on the part of the person and to refund the amount. But where a forfeiture is the contemplation between the parties, something the one person is entitled to forfeit.
Sir, the difference between earnest money and advance is what you pay to enter into a contract, right? Earnest money is you keep it as a security to honor the contract and say that I'll perform my obligations, I'll pay you the rest of the money in installments or whatever it has been contemplated. Advance is what you pay, something like goodwill to acquire a right over the property. I think
either forfeiture or penalty can be imposed.
Nageshwara, concisely you're trying to put it as EMI. Earnest money. Earnest money అనేది ఇప్పుడు suppose loan ఇచ్చారు, that mostly that word is used as far as bankers are concerned. Why? Because suppose a housing loan is given to you, you have to pay EMIs, that is monthly installments you pay. That includes only the interest what you pay. But earnest money అనేది మనం వాడము ఇక్కడ, అడ్వాన్స్ అని వాడతాం.
It is the prerogative of the government, sir. But earnest money will be forfeited after the tender.
Advance mostly is used in rental agreements and lease deeds. ఇక్కడ మనం అడ్వాన్స్ అనేది paid a sum of rupees towards so and earnest money వాడతాం loose గా, but it's not exactly earnest money. And to show your sincerity that you'll honor the contract in total. Right, sir? Next.
Okay. Thank you, sir. Thank you so much.
Welcome, sir.
Jaikar, sir.
ఎక్సలెంట్ సంతానం గారు తిరువారు.
నమస్కారం.
నమస్కారం. వణక్కం.
వణక్కం. ఆదాబ్ వర్సే. సత్ శ్రీ అకాల్.
సార్ ఎప్పుడు ఎదిగాను సార్?
Fine, sir. Solomon.
Sir, just now you mentioned section 19,
Yeah.
which brushes aside a defective title.
Yes.
And made all the due diligence.
Yes.
Yet the title becomes all right.
No, it doesn't become proper. But one thing is the person who has transferred the property, agreed to sell the property, he cannot question it later, saying that you are not a bona fide purchase. Bona fide purchase is a relative term. It depends on facts and circumstances.
That is the purchaser who will be displaced.
Only the purchaser gets that right.
Sir,
Purchaser gets that right.
Would be displaced when lis pendis or pendilite.
Yeah.
In terms of original owner showing up his face.
Yeah.
What happens to his credentials?
Sir, I will try to discuss this position when I come to the Transfer of Property Act, sir. There we come across two things: sale by ostensible owner, sale by holding out, ostensible owner, then name out that partner and habit. What are the exceptions to that? How then you got feeding the grant by estoppel, so on and so forth. About 10 sections are there which covers your question. I will
Okay,
deal
sir,
with when I come to.
right now, we reserve that discussion.
Yeah, we'll reserve it for the Transfer of Property Act, sir.
Quadnon, Nemo
Name out that
quadnon.
partner and habit.
Yes, so what, in this context, when the agnate who fabricated the original Pahanis and started selling,
Right.
that is the property which does not belong to him,
Right.
okay, and last 30 years, he is trying to show fabricated Pahanis.
Right.
Where before 30 years, the original owner is live and kicking even now.
Yes.
Where VRO and the revenue officials colluded to fabricate this Pahani, and the EC is showing for the last 30 years the fabricated names.
Sir.
What is
Sir,
the legal recourse?
yeah, here you have got a maxim called vigilantibus, non-dormantibus, jura subvenient. Law comes to the rescue of a person who is vigilant of his rights, takes the earliest available action, and corrects the wrongdoer. But when a person who is the actual owner allows his agent to masquerade in the public as the real owner and does not correct him, a person who acquires rights over the property, his rights cannot be defeated. That is the basis of the law.
Yes, sir. But the original owner has been knocking all the legal doors. The revenue officials, he has put up a section 5B, an appeal to correct the fabricated Fahanis, and appeal with the collector, and
Yes.
appeal with the municipality to demolish all the illegal constructions of the new buyers.
Right.
So CCLA has been asked how mutations have happened.
Right.
CCLA wide additional director of survey and land and settlements has told we have no records to show these mutations. So these many evidences are there during this currency of his expression of his rights of ownership.
Right. The question is, sir, at the most, even though you may have a genuine case and all, delay for so many years, you have kept quiet, you have allowed third party.
Sir, all this, see, at one point of time, there was there is a perpetual injunction also to go to his property, which is holding good for lifetime, assignees, legal heirs, down the generations below. It is holding good, and that being also disobeyed. So order 39, full 2A also is being pressed, and there is a ongoing trial case. In that is case,
The proper remedy for you would be to amend the plaint and ask for mandatory injunction to pull down the structures. You cannot embark on that permanent injunction and say, I've got a right.
Repeat, sir, repeat.
You have to amend your plaint and ask for mandatory injunction to remove the structures.
Okay.
Unless you do it, your degree is of no use to you.
Already perpetual injunction is there, disobeying is there, which is valid with the evidences. Section, 65B is also not required. NFSL, forensic lab certification is also not required because live evidences we are showing. Over and above, we need to do mandatory injunction.
Yeah, you are from Andhra area, Telangana area, sir.
Telangana, sir.
Telangana. In Telangana, we don't have the what is called a remedy for taking under the land grabbing act. You have to only go to the High Court by Article 227 of the Constitution.
227.
Yes,
See,
sir.
while the trial is on,
Yeah.
Section 151 CPC or 181 CPC, 482 CRPC, inherent powers can be invoked.
Inherent powers with the court, lower courts are not doing it, sir. You have to only go to the High Court and take a direction.
Sir, I am talking about section Article 226, 227 only, sir.
Yeah, Article 226, you can what they have not done, you can take a direction of the High Court to do that. What they have avoided to do it.
Yeah. Yet, even in the High Court prayer, we need to, apart from Order 39, Rule 2A, we need to ask for mandatory injunction to be directed to the lower court, trial court.
to permit you to ask for mandate. You need not go to the High Court for that. You can amend your plaint itself and ask for mandate injunction.
Plaint of the EP,
Not in the EP, a suit has been decreed, is it?
suit has been decreed in 94.
Then file a suit for mandate injunction now, stating all the facts.
Mandatory injunction not to interfere, not to
No,
alienate.
to remove the offending structures.
All post the decree.
Exactly, sir.
So that is status quo ante.
Not status quo, sir. You can ask the court to direct the other side to remove the structures.
In the same trial court.
Yes, sir.
Thank you so much, sir.
That's all.
Jaikar sir, thank you. And trademark advocate, you raised your question. There is some questions from your end.
Sir, good evening.
Good evening, sir.
Defendant number 3 has signed the sale agreement
Right.
on behalf of D1 and D2
Yes.
because he is the valid holder of GPA of
Right.
1 and 2.
Right. Right.
Now he is saying that no, this was done on as just a document purpose, not for anything else.
Right.
And D1 has passed away,
Right.
and D1's wife has been brought on record.
Right.
Can this sustain? Actually, I am from the plaintiff side.
That is, you are the vendor, sir.
Pardon?
You are the seller,
No, I am from the plaintiff buyer.
buyer. Okay, right, sir. See, the question is, as far as an agreement that is made by your predecessor, whomsoever it may be A, B, or C, that also binds the legal representatives also, sir. An action can be even maintained against these legal representatives.
The action can be taken against the
Against the legal
GPA.
representatives are bound by that because the estate has vested with them.
Okay, is there any possibility that we can approach the High Court directly?
No, sir, you have to file a civil suit, sir.
Civil suit only in the taluka level.
For special performance.
Okay, that was filed already.
Filed already, but have you given notice to the LR, sir?
Yes, notice was given. They rejected the notice.
Yes, sir.
Based on that rejection, we filed the specific performance.
Right.
And
Yes, sir.
that is-
That is the correct remedy, sir. You cannot go to the High Court. High Court will only say go to a civil court. Because here Andhra High Court or Telangana High Court has no original jurisdiction. Like,
Andhra, Amravati, yes.
Like Chennai and Presidency towns, the original jurisdiction is there. Here we don't have original jurisdiction. You have to go to a civil court only.
Okay, sir. Thank you. Thank you very much.
Sir, GNR advocate, you are giving some kind of questions which are put in the chat box. You can go ahead if you have questions. GNR. Are you there, sir?
Suits for specific performance of contract లో ఆల్రెడీ
చెప్పండి.
2004లో 2004లో అది అగ్రిమెంట్ ఆఫ్ సేల్ రాశారు సార్. 2016లో అది దావా ఫైల్ చేశారు. అయితే అది దావా మెయింటైనబుల్ కాదు కదా, సూట్ ఈజ్ నాట్ మెయింటైన్.
చెప్పండి.
అగ్రిమెంట్ ఆఫ్ సేల్
రైట్ సార్.
అయితే కనీసం అట్లీస్ట్ డిఫెండెంట్ కి నోటీస్ కూడా ఇష్యూ చేయలేదు కనీసం.
సరే.
దీని మీద ఆల్రెడీ ట్రయల్ స్టేజ్ లో ఉంది దావా.
You can ask for your notice. You are not made a defendant.
I am for defendant, you are defendant, sir.
Defendant. The question is 3 years. Article 54 kinda, it is 3 years from the date of agreement. That is the period mentioned for filing a suit for specific performance. If no period is fixed, it is 3 years from the date when the refusal comes to the knowledge. Then third thing is, if there is a fraud played, there is no limitation for fraud.
Sir.
Nice, Ligar, you're asking some questions.
Thank you.
Nageswara, you want to ask certain questions? You have a question to ask, Nageswara?
With reference to subsequent transfer, one of our friends writes, sir, as you said in the parent enactment section, party of the transfer of property act, which says subsequent transfer is always subject to first transfer, and the very illustration itself is the agreement of sale mentioned in section 4.
Section
And
52, section 52 of the Transfer of Property Act talks about dependence. During the
Dependence.
pendency of a litigation, if any purchase is made either by the plaintiff or the defendant without the leave of the court, such purchase is bound by the final order that is passed by the court. The question is, it is kept alive. If the final order goes against you, then the purchaser also does not get title, sir.
It is subject to outcome of the result, subject to outcome of the suit. As
Exactly.
long as it is not consummation of transfer.
And normally in such cases, Mr. Nageswara, the person who
Because
purchases
last
the
year,
property, the person
last
who
year,
purchases the property finances the litigation.
so Supreme Court has last said that in the contempt proceedings, the court entertaining the contempt proceedings also is competent to cancel the document,
It can be.
because the execution of the document is against the orders of the court, and that therefore there is no question of dependence consideration in the
Section
matter.
52.
Yeah, as long as it is not consummation, considerations of 52 are kept aside for the time being.
Right.
Deepthi Reddy, you have certain questions? You posted some questions in the chat box.
Yes, sir. This is regarding the cancellation of
Decree.
a
Decree.
decree. Is it applicable to other acts apart from the specific performance act?
No, madam, actually, decree, that's why I said cancellation of instruments and decrees. It is also applicable to any document covered by the Transfer of Property Act, the law of conveyancing, or anything that is in writing, which if allowed to remain, is going to cause prejudice to you. It is vitiated by fraud, so on and so forth. Those are the documents which which come under the purview of cancellation. And if you are a party to the document, you can file a suit for cancellation. If you are not a party to the document, you have to file a suit for declaration. A suit for cancellation will not lie. I'm making myself clear to you, please.
Yes, sir. Yes, sir. Thank you so much.
So just to remind you people, we are left only with two topics in the specific relief act. One is injunctions, and another is what are the matters where relief is not granted. Then after that, straight away, I will go to the second part of it. If I'm given class, that is art of cross-examination in civil and criminal matters, or the ethics which you have to play, or what is called how you behave before a court, how you address a court, how you don't disrespect a court, what is the relationship you must have with the bench, and what must be the relation bench and the bar. All these things will be highlighted in the third part of it. So in the next thing tomorrow I shall complete. I take injunctions will take sufficient time because I deal with various aspects, including the civil procedure code as well as the specific relief act. What are the ingredients that are to be satisfied? Because this is injunctions is what is feeding most of our civil advocates today. So injunctions, we have to be perfect. Injunctions can be in civil law as well as in the trademarks and copyrights also. It can be obtained. So any more questions, please?
Deepthi Reddy. And certain other people are there. Nageswara garu ayipoyaru.
Jayakar kuda ayipoyindi.
Jayakar garu ayipoyaru. VNR garu ayipoyaru. All right. Anything else? Sridhar, any more questions from anybody?
Nothing. Anyhow, tomorrow is there, if at all anything is there, tomorrow they will cover.
Tomorrow I've left two topics in specific relief act. I'll cover it and then go to the next subject.
Yes, sir.
That is the art of cross-examination in civil and criminal matters.
Yes, sir.
All right, madam. See you.
With
Good
that,
night.
With that, we are closing
We'll
today's
update you.
session. And tomorrow morning at 7 o'clock, we have class of evidence. You please log in at that time. In fact, in the same link. Right?
7 o'clock.
That is morning 7 o'clock.
మీరు వద్దు సార్
Morning,
మీరు వద్దు సార్ సార్
I sleep at 1 o'clock.
మీరు వద్దులేండి సార్